with docket number E2 sub 1342. I am Karen M. Kimmerite, a commissioner on the North Carolina Utilities Commission. With me this afternoon are Chair Charlotte A. Mitchell and Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., and William M. Brawley and Tommy Tucker. I now call for hearing in docket number E2 sub 1342 in the matter of application of Duke Energy Progress LLC for approval of demand-side management and energy efficiency cost recovery rider pursuant to North Carolina General Statute Section 62-133.9 and Commission Rule R8-69. Before we proceed further, and is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Okay. Let the record reflect that no such conflicts were identified. North Carolina General Statute Section 62-133.9D authorizes the Commission to approve an annual rider to the rates of electric public utilities to recover all reasonable and prudent costs incurred for the adoption and implementation of new demand-side management and energy efficiency that I'll collectively refer to as DSM-EE measures and DSM-EE programs. Commission Rule R869 schedules an annual proceeding to establish the DSM-EE rider for Duke Energy Progress LLC, which I will refer to as DEP. On June 11, 2024, DEP filed an application to adjust its annual DSM-EE cost recovery rider, along with the pre-filed direct testimony and exhibits of its expert witnesses. The public staff, which represents the using and consuming public, is a party to this proceeding pursuant to North Carolina General Statute Section 62-15D. Further, the Commission permitted the interventions of the Carolina Industrial Group for Fair Utility Rates 2 and the Carolina Utility Customers Association, Inc. On July 5, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice that I will refer to as the scheduling order. On July 9, 2024, DEP updated its application through a supplemental filing. On August 26, 2024, the public staff pre-filed the direct testimony of its expert witnesses. On September 4, 2024, DEP pre-filed the rebuttal testimony and exhibits of its expert witnesses. On September 9, 2024, DEP and the public staff filed a joint motion requesting that the Commission excuse all expert witnesses from testifying at the September 16, 2024 hearing and accept the expert witnesses' pre-filed testimony and exhibits into the record. The Commission granted the motion by order dated September 13, 2024, including accepting the pre-filed testimony and exhibits of all expert witnesses into evidence. On September 12, 2024, DEP filed the required affidavits of publication. That brings us to today. The expert witness hearing having been canceled, this hearing is being held for the limited purpose of receiving testimony from public witnesses. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon, Presiding Commissioner Kimmerite, Chair Mitchell, members of the Commission, LaDon Toon, Associate General Counsel, on behalf of the applicant, Duke Energy Progress, LLC.
Good afternoon.
Good afternoon.
Good afternoon. I'm Will Freeman, and with me is William Creech. We're members of the public staff here on behalf of the using and consuming public.
Good afternoon.
Good afternoon. My name is Amanda Hawkins. I'm with Brooks Pierce, and I'm here on behalf of CECA.
Good afternoon.
SIGFR is not making an appearance in this public witness hearing.
Okay. Thank you for the clarification. Mr. Freeman, has the public staff identified any public witnesses present to testify in this docket?
We have not.
Okay.
I'm sorry, Commissioner.
Okay. And for clarity of the record, is there anyone present this afternoon who wishes to provide testimony as a public witness in this hearing? If so, please identify yourself at this time. And will the record reflect that no public witnesses are here and asked to be identified? With that, the Public witness, there are no public witnesses, so I will close the public witness hearing and we will move on to the next hearing before the commission today. So I will proceed with docket number E2 sub 1343. And again, good afternoon. Let's come to order and go on the record. I am Karen M. Kimmerite, a commissioner on the North Carolina Utilities Commission. With me this afternoon are Chair Charlotte A. Mitchell and Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. I now call for hearing in docket number E2 sub 1343 in the matter of application of Duke Energy Progress LLC for approval of Clean Energy and Energy Efficiency Portfolio Standard Compliance Report and Cost Recovery Rider pursuant to North Carolina General Statute Section 62-133.8 and Commission Rule R8-67. And before we proceed further, and is required by the State Government Ethics Act, I remind members of the commission of our duty to avoid conflicts of interest and inquire at this time whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. North Carolina General Statute Section 62-133.8H provides for an annual Clean Energy and Energy Efficiency Portfolio Standard, or CEPS, rider for each electric public utility to recover all reasonable and prudent costs incurred to comply with the CEPS requirement for the state. On June 11, 2024, Duke Energy Progress LLC, that I will refer to as DEP, filed an application for approval of CEPS Cost Recovery Rider in 2023 CEPS Compliance Report, as well as the pre-filed direct testimony and exhibits of its expert witnesses. The public staff, which represents the using and consuming public, is a party to this proceeding pursuant to North Carolina General Statute Section 62-15D. Further, the Commission permitted the interventions of the Carolina Industrial Group for Fair Utility Rates II and the Carolina Utility Customers Association, Inc. On July 5, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On August 26, 2024, the public staff filed affidavits of its witnesses. On September 4, 2024, DEP filed a letter in lieu of rebuttal testimony, as well as pre-filed supplemental direct testimony and an exhibit of its expert witnesses. On September 9, 2024, DEP and the public staff filed a joint motion requesting that the Commission excuse all expert witnesses from testifying at the September 16, 2024 hearing and accept the expert witnesses' pre-filed testimony, exhibits, and affidavits into the record. The Commission granted the motion by order dated September 13, 2024, including accepting the pre-filed testimony, exhibits, and affidavits of all expert witnesses into evidence. On September 10, 2024, the Commission issued an order requiring confirmation of application of new regulatory fee effective July 1, 2024. On September 11, 2024, DEP filed an updated schedule incorporating the new regulatory fee. Also, on September 11, 2024, the public staff filed a letter stating that DEP's updated schedule accurately incorporates the updated regulatory fee. On September 12, 2024, DEP filed the required affidavits of publication. On September 13, 2024, the Commission issued an order excusing witnesses, accepting testimony, and canceling the expert witness hearing and requiring proposed orders. In the order, the Commission excused all witnesses from appearing and testifying at the expert witness hearing, accepted into evidence the witnesses' pre-filed testimony, exhibits, and affidavits into evidence, and canceled the expert witness hearing. That brings us to today. As the expert witness hearing has been canceled, this hearing is being held for the limited purpose of receiving testimony from public witnesses. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon, Presiding Chair, members of the Commission. Robert Kaler, appearing on behalf of Duke Energy Progress.
Good afternoon.
Good afternoon, LaDon Toon, also appearing on behalf of the applicant.
Good afternoon.
Good afternoon. I'm Will Freeman, and with me is William Creech. We're with the public staff here on behalf of the using and consuming public.
Good afternoon.
Good afternoon, Amanda Hawkins on behalf of CECA.
Good afternoon.
SIGFA is not making an appearance in this
Okay.
public.
Thank you again for the clarification.
One more. Thank you.
Okay. Are there any preliminary matters that need to be addressed at this time?
Not from the applicant.
Okay, thank you. And to the public staff, have you identified any public witnesses present to testify in this docket?
The public staff has not identified any witnesses to testify at the public hearing.
Okay. And for clarification of the record, I will check to see if there is anyone present this morning who wishes to provide testimony as a public witness in this hearing. And if so, please come forward and identify yourself at this time. Okay. Let the record reflect that no public witnesses are present for this hearing. And with that, this public witness hearing is completed, and this hearing we will go off the record in this hearing, and we will move to the next hearing before the commission today, which is in docket number E2, sub 1344. So good afternoon. Let us come to order and go on the record. I am Karen M. Kimmerite, a commissioner on the North Carolina Utilities Commission. With me this afternoon are Chair Charlotte A. Mitchell and Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. I now call for hearing in docket number E2, sub 1344, in the matter of application of Duke Energy Progress LLC for the approval of the competitive procurement of renewable energy program cost recovery rider pursuant to North Carolina General Statute Section 62-110.8 and Commission Rule R8-71. Before we proceed further, and is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. North Carolina General Statute Section 62-110.8 requires Duke Energy Progress LLC, or DEP, to file for commission approval a program for the competitive procurement of energy and capacity from renewable energy facilities with the purpose of adding renewable energy to the state's generation portfolio in a manner that allows the state's electric public utilities to continue to reliably and cost-effectively serve customers' future energy needs, which I will refer to as the CPRE program. Further, North Carolina General Statute Section 62-110.8H permits DEP to recover its CPRE program costs through an annual rider established pursuant to North Carolina General Statute Section 62-110.8G. On June 11, 2024, DEP filed an application to adjust its annual CPRE program cost recovery rider, as well as the pre-filed direct testimony and exhibits of its expert witnesses. The public staff, which represents the using and consuming public, is a party to this proceeding pursuant to North Carolina General Statute Section 62-15D. Further, the Commission permitted the interventions of the Carolina Industrial Group for Fair Utility Rates II and the Carolina Utility Customers Association, Inc. On July 5, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On August 26, 2024, the public staff filed affidavits of its witnesses. On September 4, 2024, DEP filed a letter in lieu of rebuttal testimony, as well as pre-filed supplemental direct testimony and exhibits of its expert witnesses. On September 6, 2024, DEP and the public staff filed a joint motion requesting that the Commission excuse all expert witnesses from testifying at the September 6, 2024 hearing and accept the expert witnesses' pre-filed testimony, exhibits, and affidavits into the record. The Commission granted the motion by order dated September 13, 2024, including accepting the pre-filed testimony, exhibits, and affidavits of all expert witnesses into evidence. On September 12, 2024, DEP filed the required affidavits of publication. That brings us to today. As the expert witness hearing has been canceled, this hearing is being held for the limited purpose of receiving testimony from public witnesses. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon again, LaDon Toon on behalf of the applicant, Duke Energy Progress, LLC.
Good afternoon again.
Thank you.
Good afternoon. I'm Will Freeman, and with me is William Creech. We are attorneys with the public staff here on behalf of the using and consuming public.
Good afternoon.
Good afternoon, Amanda Hawkins on behalf of CECA.
Good afternoon.
Good afternoon. I just want to clarify that while SIGFR is a party to this docket, we are not making an appearance in the public witness hearing.
Okay. Good afternoon. Thank you for the clarification. Are there any preliminary matters that need to be addressed at this time?
None from the applicant.
And for the public staff, have you identified any public witnesses who are here to testify in this docket?
The public staff has identified no witnesses here for the public hearing.
Okay. Thank you, Mr. Freeman. And for clarification for the record, is there anyone present this afternoon who wishes to provide testimony as a public witness in this hearing? If so, please identify yourself at this time. Let the record reflect that there are no public witnesses present for this hearing. And since there are no public witnesses present for the hearing, public witness hearing has been concluded and we'll go off the record. So we will move on to the next hearing, which is in docket number E2, sub 1345. Good afternoon. Let us come to order and go on the record. I am Karen M. Kimmerite, a commissioner on the North Carolina Utilities Commission. With me this afternoon are Chair Charlotte A. Mitchell and Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. I now call for hearing in docket number E2 sub 1345 in the matter of Duke Energy Progress LLC's annual joint agency asset rider adjustment application. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. North Carolina General Statute Section 62-133.14 provides for the recovery through a rate rider of costs incurred by Duke Energy Progress LLC or DEP to acquire, operate, and maintain interests in electric generating facilities purchased from a joint municipal agency and permits DEP to recover its associated costs through an annual cost recovery rider. On June 11, 2024, DEP filed its joint agency asset rider application, as well as the pre-filed direct testimony and exhibits of its expert witnesses. The public staff, which represents the using and consuming public, is a party to this proceeding pursuant to North Carolina General Statute Section 62-15D. Further, the Commission permitted the interventions of the Carolina Industrial Group for Fair Utility Rates II and the Carolina Utility Customers Association, Inc. On July 5, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On August 14, 2024, DEP pre-filed supplemental testimony and exhibits of its expert witnesses. On August 26, 2024, the public staff filed a notice and affidavit of its expert witness. On September 4, 2024, DEP filed a letter in lieu of rebuttal testimony, as well as pre-filed supplemental direct testimony and an exhibit of its expert witness. On September 9, 2024, DEP and the public staff filed a joint motion requesting that the Commission excuse all expert witnesses from testifying at the September 16, 2024 hearing and accept the expert witnesses' pre-filed testimony, exhibits, and affidavits into the record. The Commission granted the motion by order dated September 13, 2024, including accepting the pre-filed testimony, exhibits, and affidavits of all expert witnesses into evidence. On September 12, 2024, DEP filed the required affidavits of publication. As the expert witness hearing has been canceled, This hearing is being held for the limited purpose of receiving testimony from public witnesses. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Presiding Chair, members of the Commission, Robert Kaler appearing on behalf of Duke Energy Progress.
Okay. Good afternoon.
Good afternoon. I'm Will Freeman, and with me is William Creech of the public staff here on behalf of the using and consuming public.
Okay. Good afternoon.
Good afternoon, Amanda Hawkins on behalf of CECA.
Good afternoon.
SIGFR is a party to the sub-docket, but is not making an appearance in this public witness hearing.
Okay, thank you. Are there any preliminary matters that need to be addressed at this time?
None from the applicant.
None from the public staff.
And for the public staff, has the public staff identified any public witnesses present to testify in this docket?
The public staff has not identified any witnesses to testify at this hearing.
Okay. And for clarification of the record, is there anyone present this afternoon who wishes to provide testimony as a public witness in this hearing? If so, please come forward and identify yourself at this time. Okay. Let the record reflect that no public witnesses are present for this hearing. And since no public witnesses are hearing, this public witness hearing is concluded and we will go off the record. We will now move into our last hearing this afternoon, and it is in docket number E2, sub 1341. Good afternoon. Let us come to order and go on the record. I am Karen M. Kimmerite, a commissioner on the North Carolina Utilities Commission. With me this afternoon are Chair Charlotte A. Mitchell and Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, and Tommy Tucker. I now call for hearing in docket number E2 sub 1341 in the matter of application of Duke Energy Progress LLC relating to fuel and fuel-related charge adjustments for electric utilities pursuant to North Carolina General Statute Section 62-133.2 and Commission Rule R8-55. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. Pursuant to North Carolina General Statute Section 62-133.2, the Commission is required to conduct annual fuel charge adjustment proceedings for electric utilities engaged in the generation or production of electricity by fossil or nuclear fuels. Commission Rule R8-55 schedules an annual cost of fuel and fuel-related cost adjustment hearing for Duke Energy Progress LLC, which I will refer to as DEP, and requires that DEP use a test period of 12 months ending March 31. On June 11, 2024, DEP filed an application requesting changes in its fuel charges effective for service rendered on and after December 1, 2024, along with pre-filed direct testimony and exhibits of expert witnesses. The public staff, which represents the using and consuming public, is a party to this proceeding pursuant to North Carolina General Statute Section 62-15D. Further, the Commission permitted the interventions of the Carolina Industrial Group for Fair Utility Rates II, which I will refer to as CEPS, and the Carolina Utility Customers Association, Inc. On July 5, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. DEP updated its application through supplemental filings on July 19, August 7, and August 8, 2024. On August 26, 2024, the public staff and SIGFR pre-filed direct testimony and exhibits of expert witnesses. On September 4, 2024, DEP pre-filed expert witness rebuttal testimony and exhibits, which were subsequently corrected on September 5, 2024. On September 10, 2024, the Commission issued an order requiring confirmation of application of new regulatory fee effective July 1, 2024. On September 11, 2024, DEP filed an updated schedule incorporating the new regulatory fee. Also on September 11, 2024, the public staff filed a letter stating that DEP's updated schedule accurately incorporates the updated regulatory fee. On September 12, 2024, DEP filed the required affidavits of publication. On September 12, 2024, DEP, the public staff, and SIGFR filed a joint motion requesting that the commission excuse all expert witnesses from testifying at the September 16, 2024 hearing and accept the expert witnesses' pre-filed testimony, exhibits, and affidavits into the record. The commission granted the motion by order dated September 13, 2024, including accepting the pre-filed testimony, exhibits, and affidavits of all expert witnesses into the hearing. Let me correct that. On September 13, 2024, the commission issued an order excusing certain witnesses in which the commission excused DEP witnesses Houston, Simrel, Flanagan, McNeil, and Sykes, public staff witnesses Lawrence, Brown, McClawhorn, and Boswell, and SIGFR witness Collins from testifying at the September 16, 2024 hearing. That is the correct statement that I just mentioned. On September 16, 2024, the commission issued an order excusing DEP witness Suez from testifying at the September 16, 2024 hearing. That brings us to today. I now call upon counsel for the parties to introduce themselves for a purpose of the record, beginning with the applicant.
Good afternoon, Presiding Commissioner. LaDon Toon on behalf of the applicant.
Good afternoon.
Good afternoon. I'm Will Freeman. William Preach. We're here with the public staff on behalf of the using and consuming public.
Good afternoon.
Good afternoon, Amanda Hawkins on behalf of CEPS.
Good afternoon.
Good afternoon, Presiding Commissioner Kimmeray. My name is Ashley Stokeham with Bailey and Dixon LLP, appearing on behalf of SIGFR 2.
Okay, good afternoon. Are there any preliminary matters that need to be addressed at this time?
If I may, have two preliminary matters. One regards Mr. Sykes, as Presiding Commissioner indicated. On September 13th, Mr. Sykes was excused from appearing. However, Mr. Sykes is here today. With your permission, the company would like Mr. Sykes to appear alongside Ms. Harrington to fully respond to any questions that the commission might have.
Okay. Seeing no objection to your request, the commission will allow Mr. Sykes to appear with Ms. Harrington when she testifies.
Thank you. And then the second matter regards witnesses who were excused from appearing today. Would this be appropriate time to move the company's application and those exhibits and testimony?
Let's get through the public witness hearing, and then we will ask for all of the attorneys to introduce the testimony and exhibits into the record.
Thank you.
Okay.
No further matter.
Are there any additional preliminary matters that need to be addressed?
No, Commissioner. Thank you.
And has the public staff identified any public witnesses present to testify in this docket?
The public staff has not identified any witnesses to testify at the public hearing.
Okay. And for clarification for the record, is there anyone present this afternoon who wishes to provide testimony as a public witness in this hearing? If so, please come forward and identify yourself at this time. Let the record reflect that no public witnesses are present this afternoon. And with that, we will close the public witness portion of the hearing, and we'll move on to the expert witness portion of the hearing, beginning with DEP. And so at this time, we will hear any motions from DEP.
If this would be the appropriate time for me to renew the company's request to have Mr. Sykes appear alongside Ms. Harrington, I will go ahead and do that. Otherwise, no other motions to make.
Okay. I don't think that you need to renew that request. It's been granted. So any additional motions, we will hear them at this time.
If it's an appropriate time to move the company's witnesses which have been excused from appearing today, I will go ahead and move forward with that.
Okay, please do so.
Okay. Thank you for the clarification, Presiding Commissioner. So first, I move that Mr. Simrel's 11 pages of direct testimony filed in this docket on June 11, 2024, be copied into the record as if orally given from the stand.
Okay, seeing no objection, the direct testimony of Mr. Simrel consisting of 11 pages will be copied into the record as if given orally from the stand.
And I further move that Mr. Simrel's confidential exhibit 1, also filed on this docket, be accepted into the record under confidential seal at the appropriate time.
Okay. Seeing no objection, the confidential exhibit attached to Mr. Simrel's direct testimony will be admitted into the record confidentially.
I move that Mr. Houston's 9 pages of direct testimony filed on this docket on June 11, 2024, be copied into the record as if orally given from the stand.
Seeing no objection, the direct testimony of Mr. Houston consisting of 9 pages will be copied into the record as if given orally from the stand.
I further move that Mr. Houston's accompanying 2 exhibits be accepted into the record at the appropriate time.
Okay. And seeing no objection, the 2 exhibits attached to Mr. Houston's direct testimony will be admitted into the record.
I move that John D. Swez's 12 pages of pre-filed direct testimony filed on this docket on June 11 be copied into the record as if orally given from the stand, as well as Mr. Swez's 3 accompanying exhibits, including confidential exhibit 3.
Seeing no objection, the direct testimony of Mr. Swez consisting of 12 pages will be copied into the record as if given orally from the stand. The 3 exhibits, including Exhibit 3, which is confidential, will also be admitted into the record.
Thank you. I also move that Mr. Swez's 3 pages of rebuttal testimony filed on this docket on September 4th be copied into the record as if orally given from the stand.
Seeing no objection, the Mr. Swez's rebuttal testimony consisting of 3 pages will be copied into the record as if given orally from the stand.
I move that Mr. Jeffrey Flanagan's pre-filed direct testimony consisting of 11 pages be copied into the record as if orally given from the stand.
And seeing no objection, the direct testimony of Mr. Flanagan consisting of 11 pages will be copied into the record as if given orally from the stand.
And I move that Ms. Kelly McNeil's pre-filed direct testimony consisting of 4 pages be copied into the record as orally given from the stand.
And seeing no objection, Ms. McNeil's direct testimony consisting of 4 pages will be copied into the record as if given orally from the stand.
And finally, I move that the company's application filed on this docket on June 11, 2024, as well as the company's updated schedule incorporating the new regulatory fee be accepted into the record at this time.
Seeing no objection, the DEP's application and the updated schedule incorporating the regulatory fee will be admitted into the record.
Thank you. Nothing further.
And let's go ahead and have you call your first witnesses, and then public staff, you may move your testimony into the record after DEP proceeds.
Thank you.
At the time the company calls Ms. Harrington and Mr. Sykes to the witness table, please be careful when stepping up.
Good afternoon. If you can place your left hand on the Bible and raise your right hands. And do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Beginning with Ms. Harrington, would you please state your name and business address for the record?
Dana Harrington, 525 South Church Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I am a Rates and Regulatory Strategy Manager with Duke Energy.
Now turning to you, Mr. Sykes, would you please state your name for the record as well as your business address?
Yes. My name is Brian Sykes and my business address is 525 South Tryon Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I am employed by the company as a Director of Rates and Regulatory Planning, overseeing numerous annual rider proceedings for both Duke Energy Carolinas and Duke Energy Progress, including the annual fuel adjustment rider.
Turning back to you, Ms. Harrington, did you cause to be pre-filed on this docket on June 11, 2024, 13 pages of direct testimony, 8 exhibits, and supporting work papers?
I did.
Did you also cause to be pre-filed in this docket on July 19, 2024, 8 pages of supplemental testimony, 9 exhibits, and supporting work papers?
Yes.
On August 7th, 2024, did you cause to be pre-filed in this docket 5 pages of second supplemental testimony, 9 exhibits, and supporting work papers?
I did.
And subsequently, on August 8th, 2024, did you file a corrected version of your August 7th second supplemental testimony?
Yes, I did.
Do you have any changes or corrections to your direct testimony, supplemental, or second supplemental testimony as corrected?
No, I do not.
If I were to ask you the same questions that appear in your direct, supplemental, or second supplemental testimony as corrected, would your answers remain the same?
Yes, they would.
Did you, Ms. Harrington, along with Mr. Sykes, cause to be pre-filed in this docket on September 4th, 2024, 14 pages of joint rebuttal testimony?
Yes, we did.
In addition to filing joint rebuttal testimony with Mr. Sykes, did you, Ms. Harrington, also file 9 exhibits and supporting work papers?
Yes, I did.
And subsequently, on September 5th, 2024, did you cause to be pre-filed a corrected version of your joint rebuttal testimony?
Yes, I did.
Ms. Harrington, do you have any changes or corrections to the joint rebuttal testimony as corrected, or your exhibits?
No, I do not.
And Mr. Sykes, to confirm, you jointly sponsored pre-filed joint rebuttal testimony, and you do not have any changes or corrections to that joint rebuttal testimony other than those filed on September 5th.
That's correct. No changes.
And Ms. Harrington, have you prepared a summary of your testimony, which you submitted in this docket, including the joint rebuttal testimony by you and Mr. Sykes for the commission?
Yes, I have.
Presiding Commissioner Camright, I would ask that Ms. Harrington's direct supplemental, second supplemental as corrected testimony, and the joint rebuttal testimony of Mr. Sykes and Ms. Harrington be entered into the record as if orally given from the stand, as well as a summary of testimony.
Seeing no objection, the direct, first supplemental, second supplemental as corrected testimony of Ms. Harrington will be copied into the record as if given orally from the stand. Also, the joint rebuttal testimony of Ms. Harrington and Mr. Sykes as corrected will be copied into the record as if given orally from the stand, along with the summary of their testimony.
Thank you. I'd also ask that Ms. Harrington's exhibits pre-marked for identification be entered into the record at the appropriate time.
Okay. So the exhibits identified will be identified as pre-marked, and motions can be made at the conclusion of their testimony.
Ms. Harrington and Mr. Sykes are available for commission questions.
My understanding is that cross-examination has been waived by all parties. Is that correct?
That is correct.
Okay, so Ms. Harrington, Mr. Sykes, the commission has some questions to make sure that we have a clear record and that we fully understand your direct, supplemental, and rebuttal testimony. So our questions will be covering at the same time direct, supplemental, and rebuttal testimony.
Okay.
And what I want to do is just make sure we have a clear understanding of what this proceeding is about and what DEP is asking for. So I'm going to start from the beginning with some just really preliminary questions. And so starting from the beginning, can you explain what fuel and fuel-related costs that DEP is seeking to recover in this proceeding? So in other words, what is fuel and what are fuel-related costs that DEP is entitled to recover in these types of proceedings?
Fuel and fuel-related costs are as defined by the fuel statute, so it's explicit to the parameters of what the statute allows. But that typically, in layman's terms, includes anything that is necessary to generate electricity for an end-using consumer or customer. So typically, that's natural gas, nuclear fuel, coal, purchased power, offset by revenues recovered from purchased power sales, capacity on renewable purchased power, and gains, losses on the sale of byproducts. And trying to think if I left anything out if you were looking for those types of labels. Is that the answer, the sort of thing you were looking for?
Right. So you're essentially looking for total net recovery of what your actual costs are. Is that correct?
That's correct. Each year when we come in, we have an actual period that has transpired in the past where we know actual fuel and fuel related costs. We've spent those, we've supplied energy to the customer, and we know what that cost. The year before, we would have set a prospective rate to recover what we thought those costs would be. But each year when we come in, we report whether we recovered more or less than what we needed once those actuals became known. And that would be our actual period. That's what we define as the EMF in a case like this, which would be the experience modification factor. And that is contingent on an actual period, actual known and measured costs. Like, in addition to that, we look to the prospective billing period. And in this case, that is December of 2024 through November of 2025. And we project all of the components needed to supply that fuel and those fuel and fuel-related costs to anticipated sales for that billing period. So there's a prospective component of the rate where there's an estimated cost and an estimated load. And then there's also the EMF, which has actual costs and what was actual load that those costs met.
And when you talk about determining what the prospective amount is going to be, how do you determine that? What measurements or criteria do you use to try to accurately project what prospective fuel and fuel-related costs are going to be?
I think Mr. Sykes wanted to answer some forecast questions for us.
Yeah, happy to answer that. So 2 times a year, the company produces a load forecast, and that load forecast is our best indication at that point in time of the demand that our customers will request from us. That load forecast is then used as an input to develop the fuel forecast, or what generation is required and what mix of generation is required to meet that load. From there, we are trying to time as closely as possible our forecast with an annual fuel filing, whether that's in North Carolina or South Carolina. And so when we lock in, if you will, commodity prices, we're locking in those commodity prices that exist as of a period of time as closely timed to the annual fuel filing. So that's where we're going to go look at what are the latest natural gas prices, not gas prices that were stale from 6 months ago. What are the latest and greatest prices for coal, for natural gas? What is our economic dispatch so that we can dispatch our system for the lowest cost possible to customers? So when we talk about a prospective fuel component, the prospective fuel component is driven based off of what we anticipate our customers needing and what it takes to get us to that point.
And you talked about, so historically, can you talk about whether this prospective assessment or measurement has been relatively accurate? I know that it obviously in the 2023 proceeding, there was a substantial under recovery, and then there's been an under recovery in this proceeding. But before the 2023 and 2024 proceedings, can you talk about the projections, how accurate they were, and whether kind of a range of what you're seeing for under recovery or over recovery?
Yes, I would say in the past, our forecasts have been fairly accurate, whether that's a load forecast or the fuel forecast. I think prior to recent years, we've had relative stability. So anytime we look at a forecast run compared to the previous forecast run, there's not a material change in fuel expense. So when I look back at the last couple of years, we have had to lock into a fuel forecast that included commodity prices as of a certain point in time. And if those commodity prices have changed or fluctuated throughout the year, as they have in the last few years, it's inevitable that we are going to be under recovered.
And what has been the general under or over recovery outside of the 2023, 2024 time period? What was DEP seeing as far as inaccuracies of over or under recovery?
So we have looked back at the last 10 years, and I believe that was included as an exhibit in the DEC case earlier this year. And so
That's the exhibit.
So we've seen a little bit of over recovery, a little bit of under recovery for each of the utilities. I would say it's never been a significant amount. And so the company has looked at that from one year to the next. We could have been $1 million over recovered one year, $2 million under recovered the next year, another $1 million recovered over the next year. And so over the last 10-year period, we have not seen a significant balance that either needed to be recovered or flowed back to customers.
And when you talk about a significant amount, you just talked about $1 million or $2 million. Is that how you would characterize a significant amount, either above or below $2 million? Am I understanding your testimony correctly?
Yeah. So when I look at total fuel costs that we're asking North Carolina retail customers to pay, I believe in Ms. Harrington's revenue requirement that was filed within the last week or so, the North Carolina retail costs were $1.4 billion. So yeah, so $1 or $2 million shortfall or over recovery to me is a small number that I wouldn't say it's insignificant, but it is within an amount that the company feels comfortable with.
And in the past, prior to this proceeding, and had DEP sought to true up or collect under recovered or either over or under recovered amounts from the EMF factor?
No, neither DEP nor DEC had sought to true up what that true up component is, whether it was an over recovery or under recovery. And in the DEC proceeding, we did say those were de minimis amounts, and that's why we had not approached the commission to revisit that true up component.
And before I ask you about the de minimis amounts, you talked just a minute ago about previously there'd been relative stability with your forecast.
Yes.
Can you talk about, is there no have you not seen relative stability in the past, for the past two, this proceeding, or what has changed in regard to that relative stability that you're talking about?
So I want to say it was second quarter of 2021 when we really saw fuel commodity prices significantly increasing. Prior to that, they have been relatively stable. I mentioned run from a forecast perspective. We had not seen fuel dollars or fuel expense that we would look to recover from our customers changing significantly. And so if you look back at what happened in 2021 and 2022, we saw elevated natural gas prices, elevated coal prices for a year and a half to almost 2 years. And so it was really at that point, these balances became more material. If we set a forecast price that was $2.50 for natural gas and it rose to $6 or $8, that's where the under recovery began to factor in for both DEC and DEP. We were not alone in that regard. Utilities across the nation were experiencing the same thing as DEC and DEP. And so the under recoveries that we have asked for recovery of are reflective of that change in natural gas or coal prices from the price that was baked into the forecast that set the annual fuel rates.
And currently and going forward, have you seen a return to that relative stability that you're talking about, or can we expect that there will be the stability that you've mentioned that had been there in the past? Is that what we can expect going forward?
That's what we're seeing today. Obviously, I can't look into the future and say, will that change? But I think, if you look at Ms. Harrington's second supplemental, where we agreed to update to the latest fuel forecast, we did see a reduction in North Carolina retail fuel expense of almost $5 million. So I think we're seeing relative stability in natural gas space. Again, not to say that that won't change. There could be some ups and downs, but we hope we're not in a point where we were in 2021 and 2022, where those costs are rising to $6 or $8 or more dollars per MMBTU.
Okay. And this may be a question for you, Ms. Harrington. In this proceeding, can you explain to the commission what the amounts that you're seeking to recovery during the test period, and then also for the true up for the EMF factor?
You would like the revenue requirement?
The amount that, yes, please.
Yes, the revenue requirement. Okay. As filed on my rebuttal testimony, it's Harrington Rebuttal Exhibit 2B. On line 18, that amount is $1,268,237,947.
And what is that specifically for?
That is all inclusive of everything that we are asking the commission to set rates in approval of, which includes our prospective period, our current EMF balance or under recovered balance through June of 2024, and then also our under recovered balance of the EMF from the prior fuel proceeding of $9 million.
Okay. And what is the under recovered balance for the test period?
The under recovered balance for the test year plus the 3 additional updated months of April, May, and June is $164 million.
And then for the under collected amount of $445 million, that amount was supposed to have been recovered from December 2023 through November 2024. Is that correct?
That is correct. Yes, ma'am.
And that is the approximately a little more than $9 million that you are seeking to recover as a true up of the EMF factor. Is that correct?
That is correct. As of June 2024. So there will be 5 more billing months, if I've got that. Well, we've had a couple actualized already, but 3 more billing months.
Okay. And what are the actualized billing months showing as far as that under-recovered amount of the EMF factor?
Yes, we did see some warm weather in July and August, so we have made up a little bit of that 9.2 million. As of the August actuals, we're at 4.7 million of the 2023 EMF balance. 4.7 million.
4.7 million of that is an under-recovered amount, total
ma'am.
net under-recovered amount.
Yes, ma'am.
Of the EMF factor, correct?
Yes.
And can you've talked about this to some amount, but can you explain in a little bit more detail about how you determine the amount of the under-collected EMF factor? Can you describe how you determine during the recovery months how much has been under-recovered?
Certainly. So, of course, our books and records will let us know what we spent in fuel costs during a duration of time, let's say a month, for example. And then also our books and records will tell us what we collected in revenues and who from, which customer classes paid how much of the total revenues. Once you offset the two, the revenues over the expenses, you net the difference. It's either above or below what you spent in the month, and that will depict whether we have an over recovery or an under recovery.
And let me go back to your answer about the $4.7 million of the actualized additional months that
Yes,
have
ma'am.
been determined.
Mhm.
So my understanding of the numbers that you gave is that we have about $9 million and then $4.7 million. So we're looking at from an under recovered amount from what you've been able to determine of about $13.7 million. Is that correct?
No, ma'am, that
Okay.
4.1 is cumulative.
Okay.
So that 9.2 we actually recovered some of it in July and August. It is now reduced to 4.7 in actuals. Granted, we do have 3 more billing months, September, October, and November, and we could continue to accrue more under recoveries from that balance or catch more up. So it still remains to be seen what will come in actuals in the final remaining months. Could still go up or down, but the 4.7 is where we are as of August.
And is it possible that you could ultimately end up over recovering the true up balance of the EMF?
That is possible. And as stated in testimony, the company intends to return that to customers with interest,
With interest.
if that's the outcome.
And for the under-recovered EMF balance, my understanding from your testimony is that the company is not seeking to collect carrying costs for that balance. Is that correct?
That is correct.
Okay. And can you walk us through the reasons for this approximately, according to the testimony, a little bit more than $9 million under-recovered amount of the EMF balance? For the forecast, the projected forecast of what changed. Your testimony talked about mild weather, and if that is the only reason, can you explain a little bit more about that? Or are there any other reasons why the forecast was off by about $9 million?
Are you asking about the EMF true-up amount?
Correct, yes.
I think it could be any myriad of actual factors versus the terms or the stipulations of the calculation when the rate was set. So as you know, when we set a rate, like an EMF rate typically is, the cost, so that wasn't, unknown, but the projected sales upon which you're going to speculate that you're going to recover those costs. When it comes to an EMF, that is the normalized test period sales. So the fuel statute requires that we recover those costs in like manner to the most recently approved general rate case. And by definition, the currently approved basis is normalized test period sales, which means actuals from the period over which that over or under collection came into existence, but then normalized for weather and growth. So if there were growth anomalies in that time period or weather anomalies in that time period, those are neutralized. So the fuel statute says we should set that EMF rate with the known under or over recovery, but then set it on normalized test period sales, tweaked actual sales. But then we're going to apply it to a future period. So there's always realistic abnormalities between normalized test period sales and whatever actual sales actually occur in a future month. That's going to depict your revenues. So if you set that rate back in history, but you build sales, you bill your customers in real time, those may sway in any number of reasons due to actual factors. Could be weather, typically weather or growth. Could be additional customers coming onto the system or off the system. A lot of any real-time factor that would determine a customer's load, basically. So back to your I'm trying to recall your question.
So my specific question.
How did it go from 9.2 to 4.7?
Or explain what were the factors in this particular situation that resulted in an under recovery of a little more than $9 million of the EMF, the true up you're trying to true up the EMF. What happened? Why did you under recover $9 million?
I think it was just commensurate with how large the balance was to begin with. It was $445 million as of the close of the prior actual period. So that amount was unprecedented. And again, as we've spoken on the record already today, it was due to volatility that occurred in natural gas prices and coal prices back in 21 and 22. So when rates are set historically, and then some, global economic issue occurs like the war in Ukraine and prices skyrocket, some things unforeseen can drive prices up that weren't historically baked into our expectations. So, and then it takes time to go through the regulatory process to be made whole. Luckily, our rates are going down in this case. It appears we're very close to recovering that full balance and hope to see more normalized volatility or lack of volatility in the future.
If I can just add, it truly, the driver is the magnitude of the fuel. So we were dealing with fuel costs for North Carolina retail of over $2 billion. Ms. Harrington just stated this year it's $1.3 billion. So just the magnitude of fuel expense. And if I look back over the 10-year period, we're generally $100 million over recovered or under recovered or less. So Ms. Harrington just stated $445 million under recovery in the prior year. So it's, again, just the magnitude of the fuel expense because commodity prices did skyrocket in the last couple of years.
And I don't want to belabor this, but can you just help me to understand, just state for the record, how the magnitude of that $445 million, how that relates to a greater under recovery? Like, why would we have a greater under recovery due to the magnitude of the $445 million that was not recovered?
If I can go just a little bit deeper, when we come in for an annual proceeding, I mentioned earlier, we come in with a fuel forecast that is timed as closely to that direct filing as possible. When we were here a couple of years ago, so what set the EMF under recovery from last year was the difference between actual commodity prices that came in during the test period versus where we had locked them in for the forecast. So if we had a forecast for natural gas of $2.50 per MMBTU and it came in at $6, that delta primarily is what's driving the EMF under recovery.
Okay. And your testimony, Ms. Harrington, did refer to mild weather. Was that a reason also for the under recovery of the EMF?
I would say it is. So if we look at what's happened this year, we've primarily had mild weather. July, August were exceptions, but leading up from January through March in the DEC case, or January through June for the DEP case, we were experiencing milder weather than forecasted.
Okay. And so the public staff's position in this proceeding is that DEP should not be able to perform essentially what they're calling a true-up of a true-up. And they describe that as essentially being retroactive rate making. Can you explain your position about if you agree or disagree with the public staff's position? And if you disagree, why do you disagree with that position?
I'll take that one. So neither one of us are an attorney. But we have been advised by our counsel that the fuel statute does allow recovery of fuel expense. And we do not make a profit on fuel. So if we spend $1 on fuel, we expect to recover $1 in revenue. And so we have experienced a shortfall. And so we're here to ask the commission to approve the company's request to be made whole on every fuel dollar that it has spent on behalf of customers who have already consumed the electricity.
And going forward, will your practice change for DEP if you either over recover or under recover? You will come in and have a true up of the EMF if you determine that there is an over or under recovery. Will that be a change in practice going forward?
A change in practice other than this year where we're asking for that request.
And related to that, public staff witnesses McLaughlin and Boswell state that historically there have not been, with the exception of the last, the DEC proceeding, that there have not been true ups for either under or over recoveries of EMF. Do you agree? And if you agree, can you explain why the commission should depart from that historical practice in this instance and going forward?
Yeah, we believe the commission should depart from that practice. As I mentioned earlier, every dollar of fuel that we spend, we should expect $1 of recovery. And so I can't speak to why it has or hasn't been done in the past. I know even Duke Energy Carolinas, Duke Energy Progress have not come in. I can't speak to other utilities, but it seems logical that we should be made whole on our fuel costs. It's a matter of sound policy.
And likewise, if the costs go the other way, in circumstances where we were to under collect, customers should be returned those funds as well. So this is a mutually beneficial request.
And to correct the record, you mean when you over collect?
Oh, did I say under? When I over collect, did I say under? I'm sorry. Thank you for correcting me. Yes.
Okay. And then moving on to, did you both have an opportunity to read public witness Brown's testimony?
Yes.
Okay, and I don't know that you need to turn to his testimony because I'll tell you what was said, but on page 9, line 6 or 20, there was testimony that both DEP and DEC have proposed new EMF factors to true up under recoveries of their respective 2023 EMFs. And the testimony from public staff is that DEP and DEC use different methodologies to calculate their proposed EMFs. And my first question is, do you agree with public staff witness Brown that DEP and DEC have used different methodologies to calculate the new EMFs, the true ups of the EMFs?
Yes, I do agree that we use different denominators, meaning what forward-looking sales would we expect to recover those rates based upon. I used my judgment that the original EMF rate was based on normalized test period sales over a term, which was, let me take myself a year back, December of 2022 through November of 2023. Did I get my years right, but back in the 2023 EMF period. And at that time, normalized test period sales was the test period. Oh, the test period. So the test period ends in March. So that would have been April through March, April of 22 through March of 23, I believe. It's the 2023 actual period. But anyway, that's the normalized test period. So I used the same. I just carried forward the exact same denominator as the basis upon which that 9.2 million needed to be recovered. I had bifurcated that 9.2 million explicit to the customer classes in my exhibits. So that was already earmarked, siloed into the classes. And then what basis did I divide by those revenue amounts per class? I used the normalized test period sales from the test period that those costs were generated in. So I just deferred back to the prior 2023 normalized test period as my basis. Personally, I just thought it was more directly related to the costs incurred. So that's the basis I used, and I kept the EMF true up consistent with the original EMF basis. I just thought that made more sense to me, but technically as we've requested to true up to actuals, what will occur downstream from this anomaly is whatever those customer classes pay, we will know. So, as we've stated already, we've got 3 more months of the billing period where the original EMF will transpire. We will know what each customer class is paying on the original EMF. And then, under the circumstances that this commission approves an EMF true up, regardless of the denominator, regardless of if it was, X or Y, we will know what each customer class pays. And so when the rubber meets the road, we will know what each customer class paid, and we will know what each customer class was expected to pay from the 2023 filing. So when we come to the conclusion of all the billed rates running, we will know who's owed monies, who's owed interest, or if we need to request more money. So yes, there was a difference in how we asked for the EMF true up, but in a long run, that affects timing. It doesn't affect the actual payee, because we will true up to actuals what each customer class is asked to pay.
And if I could just add for the record, so in the Duke Energy Carolinas 2023 proceeding, we did elect to recover the under recovery over a 16-month period. So in that proceeding, when we established the EMF, we established it over 16 months of projected sales because we did not have 16 months of normalized test period sales. So that's what's led to the difference. And in the 2024 DEC proceeding, we elected to recover the $8 million shortfall of the prior year under recovery over 2024 test period normalized sales. So we are both using normalized sales. We're just using different time periods of sales.
And just for clarification of the record, can you confirm that in the DEP 2024 proceeding, there was no stipulation with the public staff, so the collection of the under-recovered amount in DEP was over 12 months as opposed to over 16 months in DEC. Is my understanding correct?
That is correct.
Okay. And just to make sure that I fully understand the difference in methodology using different denominators, Ms. Harrington, did you prepare the methodology in the DEC proceeding?
I did not, but Mr. Sykes was involved.
Okay. And what difference would it make for the amount that will ultimately be over-collected or under-collected if the DEP proceeding used the same denominator or methodology as DEC? Is there going to be any practical difference in the amount that is either over-collected or under-collected?
Not in a dollars and cents amount. Again, each one will be contingent on its original EMF. So in the 2023 cases, each of our exhibits are by rate class. So you know each customer class what that anticipated under or over recovery was. Regardless of the basis for the EMF true-up rate, we will attribute revenues collected from that customer class against revenues expected from that customer class. And we will continue to report that back to the commission until it's a zero.
And going forward, is the company, Duke Energy, going to endeavor to try to use the same methodology for DEP and DEC to avoid confusion about how the over-recovery or under-recovery is calculated?
Yes, we will look to align our methodologies between the two utilities.
And a couple more questions. The public staff had recommended that the EMF true-up be limited to 3 months of the test period rather than the 7 months that has been calculated by DEP. Is my understanding correct that you all have calculated, or DEP is calculated using 7 months? Is
Yes,
that
ma'am.
correct?
That's correct.
And in your testimony, you stated that using only 3 months would be an arbitrary cutoff point that would, and I'm going to quote, punt historical cost to future customers beyond what is avoidable.
Mhm.
And can you explain what you mean by that, and also why timely cost recovery is important to both customers and DEP? You talked about timely cost recovery is important to not just to DEP, but also to customers. I've added a lot of questions there, but if you can
Yes.
explain your disagreement with the public staff and why you think the 7-month period is appropriate.
Certainly. Well, as you know, we experience regulatory lag. We come in once a year and request our best estimate of what we think the future period is going to cost to supply the anticipated load to customers. And then we have to look back because there's no perfect rate making, and there's always a delta, which is why we have an EMF period and we have annual proceedings. So that's kind of the nature of the beast with fuel. Gosh, now I forgot the question.
Why is it appropriate to use 7 months rather than
Timely
3
cost
months?
recovery, yes. If you think about it, we've already got some inherent regulatory lag, whether, again, regardless of which direction it's going, whether we've overcollected or undercollected, there's a lag. Let's say we were to overcollect and we owe customers money back. What if they move out of North Carolina? Then their neighbor or the person who buys their house will get the benefit of an EMF rate going the opposite direction. So timely cost recovery is best to try to either collect from or give back to the customer who used the generation that incurred the cost. It works both ways. It's mutually beneficial for the customers and for the company.
Okay. And can you explain a little bit more detail about why 7 months is more appropriate than 3 months? I mean, that is the public staff's specific concern or specific objection that 3 months is more appropriate than 7 months. And I understand about timely cost recovery, but.
Right. In addition to that, just actualize, the information's been actualized. It's known, it's measured, it's not going to change. We know what we've recovered to date through when I filed that was June numbers. And those weren't going to change. They were known and measured. So it was somewhat, I don't know a good word, but it's not logical to look backwards and go, oh, well, you owed me, $100 3 months ago. Just give me that, but you can pay me the next 1,000 next month, like in the next year. It just doesn't seem logical to postpone known and measured recoveries for a future period when we could attribute them to the current customers more closely associated with whom the costs were incurred.
Just to make it clear, so 7 months is known and certain at this
That's
point.
right.
Is that
Yes,
correct?
ma'am. Yes, ma'am.
If I can just add, Ms. Harrington's first supplemental extended the EMF under recovery for April, May, and June. So it aligns with pulling in the prior year EMF under recovery with the current year EMF under recovery. So everything's cut off clean as of June 30.
And it aligns also with DEC's request. They had requested 7 months, 7 billing period months of their EMF true up, and we had the equivalent known and measured 7 billing months to report. So we just went for as much as we could measure and assess in time to file.
Okay. Thank you. That's all the questions I have. Let me check with my fellow commissioners. Chair Mitchell?
Just a few very, very basic questions, so just bear with me as I ask them. So the back to the sub 1321 proceeding where you reported a under collection of $445 million. Does that mean, by virtue of the fact that it's an under collection, that the revenues collected by the company did not cover that $445 million expense the company incurred?
So I would say a little bit differently. The $445 million is a shortfall of revenue compared to the expense that was incurred during that test period.
Okay. So as a practical matter, just a very simplified practical matter, does that mean that the company had to expend on fuel a certain amount of money, but didn't collect sufficient revenues from its customers to cover that expenditure during the same, if we're looking at sort of a one period of time?
That's correct. So the company advances money to incur fuel for electricity generated that our customers consume. we come in once a year to ask for recovery of those dollars. And part of that includes a forecast component where we're looking forward what should happen in the next 12 months. But the second part is also a true up of what actually did happen. So if we had $1 of fuel expense, but we only recovered 50 cents, then we have a 50-cent shortfall. So that's what that $445 million represents, a shortfall from revenues compared to the fuel expense that was actually incurred.
But okay, thank you for that additional explanation. Does the company have to pay that $445 million if it wants to receive the fuel or receive the good that it needs to provide service to customers?
So I would say we pay for that fuel expense on behalf of our customers. We then have to either come in to ask for the additional 445 million shortfall, or conversely, if we over collected 445 million in that next annual fuel proceeding, we would set a rate that would flow back $445 million to customers.
With interest, correct?
With interest, yes.
So, but at the moment in time when the expenditure is made, how does the company pay for that expenditure? Again, think very practically, like where do those dollars come from that you have to pay to the natural gas supplier?
So I would say it's a combination of revenues we take in as well as funds advanced by our shareholders. So we're going out and actively buying natural gas or buying coal for the benefit, future benefit of customers. So we are, as a company, advancing those funds to buy coal, to buy natural gas, to buy nuclear fuel.
And could it be debt as well? You
Could-
said
could
funds
be a
from
combination of
shareholders,
that as well.
revenues,
Yes.
debt. Okay. Does the company incur any cost? Let's say the company has to use funds from shareholders or debt. Does the company incur any cost in using those funds to purchase the fuel?
Absolutely. So I think we've been here in the past talking about carrying costs the company incurs for known under recoveries that are sitting on the company's books and records. We have to fund those costs. We have to go out and seek short-term commercial paper
Yeah.
to fund those carrying costs.
And does the company recover those costs that it incurs? I think you just called them carrying costs in the fuel rider proceeding?
Typically, no. So I mentioned earlier, every dollar of fuel we spend, we earn $1 in revenue, or at least we're expected to. But historically, no, carrying costs are not factored into the rates that we are asking customers to pay.
Okay, why are you saying?
It's a cost that the company has to absorb. And I say typically we don't, because in previous cases where there's been a settlement, we have asked for carrying costs. So in the 2023 DEC fuel proceeding, where we had the almost $1 billion under recovered fuel, we did ask for, let's say, 4 to 5% of debt carrying costs to help us out as a company for interest that we're having to pay.
Okay. Did in the instance of the sub 1321 under recovery, did the company seek to recover its carrying costs?
No,
we
we
did not.
did not.
Okay. All right.
Your question specifically asked, did we recover it through the fuel clause and not through the fuel clause? I haven't been a witness in a base rates case, but I'm sure the company in a more global aspect handles its financing needs through a base rates request.
Meaning that the costs incurred to carry the debt to pay for the fuel expenditure might have been recovered in the context of a general rate case proceeding?
That's possible. I wouldn't have been a part of it, but we would need to recover it from somewhere.
Okay, or it would have been absorbed.
Exactly, but it would not be in the fuel proceedings.
Understood.
Yes.
I'm just trying to get out
Yes.
whether the company had to write off to expense the carrying costs associated with the under collection, or if it actually recovered it. So what I'm hearing you say is in the context of the sub 1321 proceeding, it did not recover it in the fuel rider or the EMF. In the DEC proceeding, it did recover at least some of those costs pursuant to settlement agreement entered into with the public staff subsequently approved by the commission. Is all of that correct?
That is correct.
Okay. And then Ms. Harrington, you also said it's possible that in a general rate case proceeding, the company recovered some of its cost associated with carrying this expense in working through its financing costs in that proceeding. Is that correct?
It's possible.
Okay.
I have no involvement nor confirmation, but we would need some support somehow.
Okay. And I mean, the the call, and here's, we've heard a lot about this balance, the undercollected balance over the past couple of years in both for DEC and DEP. And so my question is this, and we've heard a lot about the drag on the company's credit worthiness associated with these balances. The company, the carrying costs associated with the under recovery would have been unusual and extraordinarily unusual. Those are my words, relative to any other under collection for fuel. Is that the case, just given the balance of the under collection?
I would say the balance of the under collection as well as what's going on in the market. So if we had higher interest rates, then yes, we would have had to
That's
carry
fair.
higher costs on our books.
Okay, that's fair. Okay. Okay. Can you all help me understand? I'm going to ask you to get inside the heads of the public staff. I don't have them in front of me, so I'm going to ask you to get inside their heads and give me your explanation of their position here. I mean, why, what is it? I mean, I know we've gone through I've read your rebuttal testimony and you've rebutted their positions they've taken on this particular issue, but why is the public staff so, why is the public staff standing firm in its position here with respect to the true up of the EMF, the true up of the sub 1321 EMF?
Yes, and not wanting to speak on behalf of the public staff.
And I understand,
This
I'm
has never
asking
been
you to
done.
speak on behalf of the
I
public
would say
staff.
it's never been done before by any utility, with one exception in a settlement agreement. I believe it was a Dominion case, to revisit the EMF through a true up. And so it's never been done before. Yes, it's on. It's never been done before, but at the same time, we've never experienced such large under recoveries. The 2022 DEC fuel case was the largest under recovery we had experienced at that time, and that was a $327 million under recovery. The next year, it got even larger. We came in for a $998 million under recovery. So we have been dealing with, in 2021, 2022, very elevated commodity prices that were not included in our forecast. And so that's what led to these large under recoveries. So I would say, while it's never been asked for before, we've also never been in here with such large under recoveries. And so I think that's where it's coming from, but my defense would be we were significantly under recovered. And I would say, again, neither of us is an attorney, but when we look at the fuel statute, it makes sense that every dollar of fuel we spend, we should get $1 of fuel revenue. Our customers have already consumed the electricity that we generated, supported by that fuel expense. So to me, it makes sense that the company should be allowed to recover $1 of revenue for every dollar of fuel expense incurred.
The way I understand the public staff's position in this proceeding, and I could be wrong, so if you believe I'm wrong, you can correct me, but the public staff says, but okay, so you're under collected by $9 million, close enough. Close the books on 1321. Why not close the books on 1321? Why do you have to go after that $9 million or 9.2?
So I would say when you look at both Duke Energy Carolinas and Duke Energy Progress collectively, when we were forecasting our under recovery earlier this year, we were looking at a double-digit under recovery for both. At least $20 million, could have been approaching $30 million. That is a large amount for the utility to write off and not expect some form of recovery. If we were to write that balance off, it could impact us negatively from a credit rating perspective. And I'm not the expert from a treasury perspective, so just sharing what I've learned from discussions with them over the years. Our credit ratings take a hit. That in turn causes us to have to go seek debt that has a higher interest rate. That higher interest rate in turn would be passed on through our customers through a base rate case proceeding. So it's in the best interest of all parties involved if we are allowed to recover our fuel costs and avoid taking a hit to our credit ratings, such that customers have to bear the brunt of higher interest and the expense in the future.
Is there particular emphasis on this under recovery that occurred back in 21, 22 because of the run up in gas prices?
Particular interest from a.
Emphasis from the company's standpoint?
I would say at the end of the day, it's a conceptual. We need to recover $1 of fuel for every dollar we spend.
Are your investors focused? Are your ratings agencies focused on your recovery of these dollars?
So I haven't talked to our treasury team about this particular balance, but in previous conversations we've had with them, our credit rating agencies are relying on our ability to recover our fuel costs in accordance with the fuel statute. So they are very much looking at, if the commission allows you to recover your fuel costs over a 12-month period, you should be recovering your fuel costs over a 12-month period. When we were here before you a couple of years ago in the DEC case, we extended that recovery to 16 months. And I know one of the witnesses who sponsored testimony saying, this is why we can do that. But our credit agencies are looking at us very closely. Our investors are looking at us very closely to recover our fuel costs in accordance with the fuel statute.
All right, one last question. You mentioned a moment ago, and I can't remember which proceeding it was, but you mentioned an under recovery in the $300 million range. Do you remember that testimony?
I do.
Okay, so when the company saw, was that a DEC or a DEP?
That was a DEC case. That was sub 1263. So that would have been the 2023 filing, which covered costs in 2022.
So the company sought to recover that 300+ million under recovery through its EMF?
Yes.
And then how close did it get at the end of the EMF period?
So we actually took a write-off or an expense of $3.3 million.
So it under collected by $3.3 million, is that
Correct.
correct?
Yes.
Sorry, Kim Mitchell, I spoke over him. Okay. Okay, I have nothing further. Thank you.
Commissioner Duffley.
So following along on that 3.3 million that you've written off, I mean, where is that, I guess, sweet spot? So you have a 9.2 million recovery where you are seeking a true up of a true up, but you wrote off 3.3 million. Were there any negative consequences in the market?
I'm not aware of any.
And so where's that delta? Where do you write off versus coming back into the commission?
It's a great question. It's one I would say we've looked at over the past, but from a net perspective over the last 10 years, each utility has written off to expense a little over $2 million. So when we look at what's happened in the past, again, 1 year we may have over recovered $1 million, 1 year we may have under recovered $2 million. From a net perspective, those balances were never material enough to come back in before the commission. This year, particularly in the DEC case, and I can give an update on that if asked, but we are seeing a significant under recovery even above what we were here asking for back in June at the hearing. So it's the magnitude, overall magnitude of these balances that is why the company's coming in, and we believe that fuel statute supports our request to come in.
Okay, thank you. And then I know you're not an attorney, but on page 10 of the public staff's testimony, they bold the fact, and this goes to that retroactive rate making. They bold that and it goes to your dollar for dollar argument. They bold incurred during the test period. So I think that public staff is arguing that the true up of the true up does not fall within that test period, and just wondered what the company's response to that argument is.
I understand where the public staff is coming from. I would argue that these costs were deemed reasonable and prudent in a prior test period. So while they might not be in the current test period, the commission and other parties did agree that those costs were reasonable and prudent. And so the company's simply asking for recovery of those dollars, no more, no less.
Okay, and then circling back to my previous line of questioning, what is going to be the company's test between that 3.3 million and 9 million?
Sorry, could you repeat that?
Going back to the delta, the 3.3 million where you did not come in and ask for a true up of a true up, and the 9.2 million where you are asking for a true up of a true up. What's the test on a going forward basis?
I would say there is no test. We are going to come back in and ask for any under-recovered amount. At the same time, we would come back in and look at any over-recovered amount and flow that money back to customers along with interest. So there's no dollar number that's going to be the deciding factor. This is a prospective change, including this year, that the company would look to make in each DEC and DEP fuel proceeding.
Okay, thank you.
Commissioner Hughes.
So just following up on your answer to Commissioner Duffley, you've cited a lot the fuel statute about recovering every dollar spent, but is it a fair assessment to say that for whatever reason, whether it was the statute's intention, Duke had been carrying some risk prior to this particular docket, that and you'd be, you have the EMF to protect against risk of variation in fuel prices. That's what the EMF does. But it seems like there wasn't a protection of Duke risk against projecting usage, and that's what got you on this case, is that for while you had the EMF, the usage and the purchases were different than what you had projected. So there was that risk too. So there's two, from a risk standpoint, we're talking about investors. So I think that's fair to think about it in risk. I'm just trying to wrap my head. So just to summarize, the risk had been maybe smaller because of these amounts in the past, like less than 3 million. So it was okay for Duke to absorb that risk. And now the risk has proven that it's higher. So if I understand what you're saying, is moving forward, Duke will no longer is willing to absorb any of that risk.
I think that supports the company's position. The fuel clause does allow us to come in and recover our prudently incurred fuel expense. So it would take away the risk from that perspective, but we always face the risk. And I would say customers face the risk of when we come in and ask, and as we have in this case, we filed in June, if our fuel costs all of a sudden skyrocket, customers are going to have to pay that in a future time period. So there's a little bit of risk involved there for the customer as well, not really understanding what's going on in fuel expense space. So, they may have to pay something higher 12 months from now than we would ask them to pay today.
I think the EMF is intended to protect both parties. When you're required to true up to actuals and make no return, you true up to actuals. So that protects us and them, were we to over anticipate our costs and over collect. They're protected, we return it with interest. So they're doubly protected.
Yeah, I think the EMF does protect equal basis, but then the inequality of risk taking was in this small, if you call, lower than $3 million. That had been a risk that Duke had absorbed. So these, again, just from precedent standpoint and from investor standpoint, if you will, this new process moving forward is to take away that extra little bit of risk that in the past had been a little bit, but now it could be higher in the future. So I'm just trying to understand that.
I think that's a good synopsis, yes.
Okay,
Thank you.
Commissioner McKissick.
First, I appreciate your testimony today. I don't think there's a lot that I could ask you about that you haven't already asked and answered. In the past, there's been this amount that might have been considered de minimis, but de minimis compared to what? And I think that's the ambiguity in the way things have perhaps been addressed in the past. So I appreciate you providing clarity in terms of your position. And I think at this point, it's just a matter for us to take it under advisement and to consider how to decide we want to move forward in the future in dealing with this issue so that if it's a true up of a true up, as long as everybody is made equal in the end, or in terms of the cost that's been incurred, that perhaps might be a way to get around this de minimis amount and what it's relative to and its proportionality. So I appreciate your testimony and providing some clarity in terms of your positions.
Thank you.
Mr. Tucker.
Thank you, Commissioner. Just one question. If the commission were allow the true up of the true ups and change what I understand have been precedent for a long time of the 12-month time period, if that reduces the risk for the company, then would it be appropriate to reduce the ROE in another proceeding?
So I'm not an expert when it comes to base rate case proceedings. We are here before you in the confines of the fuel clause. And as our attorneys have advised us, there is no basis in the fuel mechanism to look at the ROE that was awarded to DEC or DEP in its most recent rate case. I would just say we are here before you today to request recoverable costs that the fuel clause allows.
Just one follow-up, though. Do you not think that what you're asking for reduces the risk for the company?
In this instance, it reduces a risk where we are under recovered, but I think it also benefits customers in the event we are over recovered. We would flow any over recovered funds back to customers.
So I guess your earlier statements were dollar for dollar, and that's kind of where your position is?
Yes, and again, that as to the company's benefit or to customers' benefit, every dollar, whether it's over recovered or under recovered, each party would be made whole respectively.
Wow, that'd be a great business model, wouldn't it, for the real world?
Yes.
Thank you.
Okay, I think we've come to the end of commission questions, so I will take questions on commission questions. Public staff?
I just want to make sure I understood. I think that you said through the end of August that the balance now is 4.7 million.
Yes, sir.
Okay. And it's being paid off quicker than projected in that case.
In our situation, yes, that's not the case for DEC.
I understand. But so we start with 445 million. The current under is about 4.7 million. That means approximately 98.9% is on track to be collected of the expenses.
I trust your math on that percentage.
Oh, okay.
Yeah, that's close enough in my, yeah, sure.
Thank you. I don't have any more questions.
Are there any questions on commission questions from Duke?
No questions. Thank you.
Okay, that takes us to the end of commission questions, and I will now hear motions from the parties, beginning with the public staff.
Thank you, Presiding Commissioner. The public staff filed testimony on August 26th of the public staff witness Evan Lawrence. He filed pre-filed testimony consisting of 10 pages and also an appendix setting forth his qualifications consisting of 1 page. The public staff would move into evidence and the record his testimony as if given orally from the stand.
Okay. Seeing no objection, the testimony of public staff witness Lawrence consisting of 10 pages and 1 appendix will be copied into the record as if given orally from the stand.
Thank you. 2 more. On August 26th, the public staff witness Daryl Brown filed pre-filed testimony consisting of 12 pages and an appendix setting forth his qualifications. That was 1 page. The public staff would move into evidence and the record, the testimony as if given orally from the stand.
Okay. Seeing no objection, the testimony of Public Staff Witness Brown, consisting of 12 pages and one appendix, will be copied into the record as if given orally from the stand.
Thank you. Finally, on August 26th, 2024, public staff witnesses James McLawhorn and Michelle Boswell pre-filed joint testimony consisting of 22 pages and two appendices. The appendices were 1 page for Mr. McLawhorn and 2 pages for Ms. Boswell that set forth their qualifications, and also that testimony included 5 exhibits. The public staff moves into evidence in the record the testimony as if given orally from the stand and moves the exhibits into the record in the same way they were marked when pre-filed.
Okay, seeing no objection, the joint testimony of public staff witnesses McLawhorn and Boswell, consisting of 22 pages and 2 appendices, will be entered into the record as if given orally from the stand.
And the 5 exhibits.
Okay. And the 5 exhibits, seeing no objection, the 5 exhibits will be entered into the record as well.
Thank you, Commissioner.
So public staff, I believe that Chair Mitchell, we see that public staff witnesses are present today. And before we do so, I think I apologize. I started with motions before excusing the Duke witnesses from the stand. So you may be excused, and we appreciate your testimony. And before we move to public staff witnesses, I believe that you'll have motions for exhibits.
Presiding Commissioner, I move that Ms. Harrington's exhibits previously marked for identification be accepted into the record at this time.
Seeing no objection, your motion is allowed. Mr. Freeman, Chair Mitchell does have some questions. If your public staff witnesses, Boswell and McLawhorn, are present and available to answer questions from the commission.
They are present and available. Thank you.
Okay, thank you.
Would the presiding commissioner like me to move their move their testimony into the record again in light of their?
I've already admitted into the record, so I think that will suffice.
Thank you.
And Mr. McLawhorn and Ms. Boswell, I know that the commission had excused you from testifying at the hearing, so we appreciate you being present and coming to answer some additional questions. I'll begin by swearing you in. Will you place your left hand on the Bible and raise your right hands? And do you swear that the testimony that you shall give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. And Mr. Freeman, if you would like to introduce your witnesses.
Thank you. Ms. Boswell, if you could please state your name and address where your address where you work and who you work for.
Sure. Michelle Boswell. I'm the Director of Accounting for the Public Staff. My address is 430 North Salisbury Street, Raleigh, North Carolina.
Mr. McLawhorn, if you could please state for the record your full name, business address, and who you work for.
My name is James S. McLawhorn. I'm business address is 430 North Salisbury Street, Raleigh, and I'm the Director of the Public Staff's Energy Division.
Thank you. I believe they're available for commission questions.
And thank you again for being present and being available for commission questions. I believe that Chair Mitchell, I have no questions, but I believe Chair Mitchell has some questions.
Good afternoon. I'll be quick, and I appreciate y'all being good sports and sitting up here. All right. I want to make sure I understand the public staff's position before we leave this room. Can you just walk us through, or walk me through it? They may understand, but walk me through your objection to the true up of the EMF, the sub 1321 EMF.
Our objection to the true up of the true up is that it is unprecedented. We do not believe that the law provides for it. It has never been done other than one time in a settlement where all parties agreed up front. It is part of rate making. There are many, and I realize we're here today to talk about the DEP fuel case, but fuel, albeit a large expense, is but one component of rate making, and there are many components to rate making. The law does not say that the company is guaranteed to recover every dollar of fuel expense that it is recovered, it is incurred. Just as the law does not say that the company is entitled to recover every dollar of any expense that is incurred. There are many fluctuations that occur beyond what are set in regulatory proceedings and what the commission authorizes. For instance, you heard testimony in recent cases about how certain levels of O&M were approved for maintenance of coal units, and the companies proceeded to reduce that level of maintenance. That was not refunded to customers either. It was not put in a deferred account. I heard some questions of the company about how did they afford to pay for the fuel costs when they didn't recover the money. Well, perhaps some of the costs they didn't spend on O&M at their coal plants was used to cover some of the fuel costs. So you've heard our argument.
Okay, thank you, Mr. McLaughlin. I just want to be sure we stay focused here on the fuel rider proceeding and not sort of wade into the issues related to the setting of base rates. And certainly I recall the testimony provided by the public staff related to concerns on O&M expenditures, particularly in the context of some of the older generating facilities, and expect the public staff to the extent it has an issue with funds expended or not expended and rates requested by the company related to certain expenses. If you all take issue with those, y'all need to, we expect you to bring those to us with specific recommendations. But in this proceeding, let's set aside the public staff's interpretation of the statute. Let's say reasonable minds can differ as to how the fuel statute could be interpreted. Is the public staff's position that to the extent the company under recovers, it should write that off to expense? My question is limited to the context of the 133.2 fuel rider proceeding.
Well, I don't read anything in there that guarantees absolute recovery of every dollar. There is one true up provided for, and if there's not complete recovery, then they would write that off as they would any other expense.
Okay, so the public staff isn't concerned about magnitude of expense or impact to the company or its customers of the magnitude of an expense?
Well, we are concerned about impacts, but when the company has faced other impacts, they've brought it before the commission when the law provides for it, and we don't believe the law provides for it here.
Well, and I would add to that our view of this has been, and I think it was the view of everyone 37 years, although I wasn't here all 37 years, despite the number of gray hairs on my head, that if you do everything over the long term and look back over the course of history, you should come to about zero. It was the goal, and I believe still is the goal. And so our view is you're going to have ebbs and flows. Just like in, I believe, 2020 per their chart, they over-recovered by $4.5 million. They didn't rush in here to say we owe this money back to ratepayers who during COVID are facing some tough times and we should give it back. They kept it because over the course of time, it should balance out. The same's held true here. Over the course of time, it should balance out. Is rate making perfect? I don't think anyone in this room would argue yes. It's inherently not. You're always going to be basing something off of some kind of estimate in order to calculate a rate. If anyone could tell you exactly what your usage would be over the next year, they probably shouldn't be working here. And if they were at Duke, probably should be making a little more than they are, realistically. So rate making being inherently flawed, whether it's fuel, whether it's rate cases, whether it's DSM-EE, it runs the gamut. Are you ever going to collect and only collect for the actual dollar spent? No, you won't. But the purpose, our belief of the rider, of the statute, was over the course of time, it works itself out.
And I guess, and I appreciate your tone, Ms. Boswell, and your response. I'm trying to get to the bottom of this, so I appreciate your trying to help me get there, and help this body get there. But I would ask you this. You know, we hear from the company, and I think it's indisputable that the under recovery going into sub 1321 was extraordinary. It was unprecedented in terms of the magnitude. And so you've just testified that the goal is always to get as close to zero as we can, sort of giving this volumetric rate, mechanism that we're using here. What about the fact that we've got the magnitude of the under recovery that we had? I mean, the public staff doesn't address that. And what I heard today from Duke's witnesses was, one of the reasons they didn't get closer to zero was the magnitude of the under recovery. Can you help me, give me a response to that
I don't
position?
think that, and subject to Mr. McClawhorn, because rates are more his thing, less mine. It's not the magnitude of the recovery. It was a matter of they forecasted a megawatt hours that were going to be used, kilowatt hours, my apologies. And there's going to be ebbs and flows. It's going to be hotter than normal. It's going to be colder than normal. There's going to be things that impact that. And their forecast was not as accurate, and therefore led to them not collecting what the rates were set to collect. It's not the magnitude of the size that we're dealing with. It is a matter of that when you take that amount and divide it by usage, their usage was wrong.
Well, the way I understand that, and that again is just by virtue of the fact that we're using the volumetric rate mechanism.
Right.
But Mr. McLaughlin, I see you roll. I don't. That's just the way I'm describing recovery.
No, I'm thinking.
Okay. Well, so I guess my question is, you're still not addressing the magnitude of the under recovery. I mean, what we heard today, what Duke has put into the record is the combined impact of the under recoveries for DEC and DEP, and I'm certain that there were other operating companies that under recovered as well. But the impact of the under recoveries to the company's financials, respond to that. Help us understand why we shouldn't place weight on what the company is saying there.
Sure. So for DEP, Ms. Harrington testified today that they are currently at about $4.7 million, if my memory serves. They still have 3 months left of recovery, so no one really knows where they're going to end up at. But assuming the 4.7 for a minute is where we end up at, they have a $4.5 million over collection in 2020. I might be missing something, but you had a pot of money that you had full access to, that you didn't refund, but now you want basically the same dollars refunded to you because it's suddenly going to hurt you. So for DEP, and I don't have all of DEC's information in front of me, my apologies, but for DEP, it doesn't make sense.
Okay, just say that, connect, you said a bunch of things in there, but just connect the dots so that when we go back and read the transcript, it's clear.
So per their chart, I believe 2020 subject to check, and my attorneys haven't thrown anything at me, so I must be near right. You had a $4.5 million over recovery. They collected too much from ratepayers. They did not give those monies back. They kept them, which was fine because over the course of time, you should come back to zero. We now sit here today And based on the testimony of witness Harrington, they sit at $4.7 million under recovered. And they're here to ask for the money back. You had similar dollars, two very different ways of treating them. I do not see how you go forth and treat one pot of money one way, another pot of money the other way, when you're $200,000 different.
The 200, help me get to the $200,000.
4.5 that they over collected in
Okay.
2020 versus the 4.7 million that they are projecting here. I'm assuming we're about 200,000 plus or minus a couple of dollars.
Well, and right. But the the way I understand the four, I think Ms. Harrington said 4.5 as of
4.7 as of, I believe, the end of June, August. Thank you.
So so that's a projection, and there's still several months to go before we have we know the actual under recovery.
Right. So
or
there's
under
3 additional months, so it could slightly go up or down.
Right. Okay. All right. I appreciate your testimony in response to my questions. I saw you all sitting in the back of the room and wanted to make sure we gave you an opportunity to help us understand your position.
Okay, so I will, Commissioner Brawley.
Ms. Boswell, you quoted two numbers, the 4.7 negative for this year and a plus 4.5 2020. Over the total period of this, what's been the net over under?
Over the 37 years, no, I have my staff going through all of the information that we have in-house to pull what the over-unders are.
Over that same period, have we had the kind of fluctuations in fuel costs that we're seeing now?
And by fluctuation in fuel cost, do you mean gas cost or just cost in general?
Of all types. The fuel rider covers everything, doesn't it?
No, it absolutely.
Yes, the under recovery in this, from this period was primarily driven by gas cost increase.
Because they mentioned that there was an initial under recovery of 455 million, and then the previous one, there was one that was almost $1 billion. It seems to me that the forecasts are becoming much more difficult to manage.
I believe the billion was the DEC case.
Okay, correction, I'm new at this. I'm going to make mistakes. Please call me down and I will own them.
It's a lot of numbers.
It is, but the magnitude of the numbers is getting to be somewhat extreme. You know, we had a long conversation. Where does the money coming from? That 455 million is additional working capital requirements to cover that cost.
It is a lot of money, but in the time that I've been here, Commissioner Brawley, rates have doubled as well. So what's 400 million now was 200 million 20 years ago. So you say, well, 400 million is a huge number. That Duke Energy Progress many years ago, for somewhat different reasons, and I won't get into that, they had about a $250 million under recovery at that time.
All right. So over the whole period, though, we're really not sure how far off we are. We just know that if we take those 2 years, that they would balance out. 2020 versus the.
Well, there have been other years when there have been over recoveries of the true up, just like there have been other years that there have been under recoveries, but yet we don't have the number right now for the entire 37-year period, understanding that $1 in 1987 is not the same as $1 today.
Sure.
And we did ask the company for this information, and we're told that they would have to go off-site to find it all. So we are working as diligently as we can with all of the cases before the public staff to go through all of our archived records, which fortunately some of my predecessors like to keep paper, and digging through all of it to ascertain what those 37 years really are.
One thing that you've mentioned is this historically, we haven't trued ups. Should we have been truing up true ups all along?
Well, we don't believe that the law allowed for that or intended for that. Had the public staff believed that, then we would have been advocating for it, particularly when there was an over collection, and I believe the commission would have too. I mean, 37 years is a long time to be silent on something.
Okay. Well, I think enough's been said on that, and thank you. I appreciate your help.
Commissioner McKissick.
First, I want to thank you for your testimony. I think it's been very clear and is where you stand as it relates to this issue. Now, certainly our statute in North Carolina is unique to us. But are you aware of any other jurisdictions that have statutes that are similar or pretty close to North Carolina that allow what I will refer to as true-ups of true-ups? Or do they pretty much, are they consistent with the way North Carolina has treated this statute going back 37 years?
Most states have fuel recovery statutes, Commissioner McKissick. The particulars of them, I can't comment on. I'm not aware of another state that does or does not have a statute exactly like ours, so I can't say.
Okay, that's fair enough. Ms. Boswell, or are you aware of any?
I am not. I haven't delved into it just because of the amount of work that we have before us keeps us busy enough that we don't necessarily have time for what ifs. And
I understand. I know you have an enormous volume and workload, and we appreciate your testimony today and the work you put into all of these cases. Anything else you want to add? It looks like you might want to say something, sir.
No, I was just going to say, had we thought that this was an issue, I'm sure we would have been researching that. And I guess it's a little bit, I feel a little bit bad if the commission reads the law the way they do, that I believe then that means the public staff hasn't been doing its job for the last 37 years.
So you felt that the statute is pretty clear and unambiguous as it is drafted in terms of addressing this issue?
Yes, sir. And that's not just my reading of it today. That is the way it was taught to me by my predecessors over the last 30-some years. So now I'm questioning, did we actually do our job or not? We should have been watching more closely to see if customers were due refunds of this amount of money.
Thank you, Bo.
So we are close to concluding this hearing, I believe, but we've been going for over 2 hours. So we're going to take a 5-minute break and then come back on the record at 3:08 to complete the hearing. Thank you. And we now will move to questions on commission questions.
None from the company.
Okay. Okay.
None from the public staff. Thank you.
Okay. So that comes to the conclusion of testimony from the public staff. And thank you for your testimony. You may step down and be excused.
Thank you.
Okay. And Ms. Toon, since we asked questions of public staff witnesses, we'll give you the opportunity for some brief rebuttal from witnesses Sykes and Harrington, if you choose to do so.
Thank you, Presiding Commissioner. So I don't think we need to bring our witnesses back up, but I think we can expedite sort of the questioning along the lines of the last 10-year history of over recovery and under recovery, which Ms. Boswell started to speak to. If you, so the company would make a motion to, for the commission to take judicial notice of an exhibit that was filed in E7-1304 as a part of Mr. Sykes and Ms. Clark's joint rebuttal testimony. It was table 1, and that will have a full picture summary of the last 10 years, which will show over recoveries and under recoveries for both DEC and DEP, which I believe Ms. Boswell and Mr. McClellan was trying to sort of provide that information in response to commission's questions.
Okay.
If I may,
Does the public staff wish to be heard?
is that the table 1 from page 18 of the testimony in DEC?
Correct.
Okay, great. Yeah, no, thank you. I appreciate your indulgence, Commissioner.
Okay. Seeing no objection, the commission will take judicial notice of table 1 I'm sorry, Ms. Harrington's testimony. Is that correct?
Table 1 of Ms. Clark.
Ms. Clark's.
And Mr. Sykes' joint rebuttal testimony filed in docket E7-1304.
Okay. So seeing no objection, the commission will take judicial notice of table 1 that is provided in DEC witnesses Clark and Syke joint rebuttal testimony and docket number E7 sub 1304.
That's correct. Thank you.
And with that, I believe that Duke needs to ask to have their exhibits introduced into the record, please.
Yes, at this time, I would request that the company's witnesses exhibits or pre-marked for identification will be moved into the record.
Okay. Seeing no objection, your motion is allowed. And for SIGFR, I'll hear motions from SIGFR.
At this time, SIGFR moves that the pre-filed confidential direct testimony of Brian C. Collins filed in this subdocket on August 26, 2024, and consisting of 7 pages of direct testimony and 3 pages of one appendix be copied into the record under seal as if given orally from the stand.
Okay. Seeing no objection, the confidential direct testimony of SIGFR witness Collins consisting of 7 pages and 1 appendix will be copied into the record as if given orally from the stand, and I will note that it will be provided confidentially.
Thank you.
Are there any additional matters that need to be addressed at this time?
None from the company.
None from the public staff. Thank you.
Okay. So post-hearing briefs and/or proposed orders are due no later than Friday, October the 11th, 2024. And with that, I want to thank the witnesses for their testimony, and we are adjourned and we'll go off the record.
Thank you.